shall constitute a bench comprising of not less than 5 members. It is a dictation to the Supreme Court or to the committee. Likewise, in 3, it says it shall constitute a bench of not less than 3 members. It is dictating the Supreme Court. Then, Section 8. Look at the expense of Section 8. Provisions of the Act shall have effect notwithstanding anything contained in any other law, rules, regulations for the timing and force or judgment of any court, including the Supreme Court. Now, where the Supreme Court has interpreted the Constitution, as I earlier said, and has set down certain rules or has interpreted the constitutional provisions, this Act, 8 Section Act, I mean, it wipes away everything and goes on to dictate the Supreme Court as to how to conduct its business. If this is not a violation of the principle of separation of powers and interference in the independence of the judiciary, what else is?
Lord, firstly, I'll submit that Section 8 is the kind of non-obstante clause that is present in numerous statutes. Now, the thing that is to be seen, and I agree with your lordships, that if your lordships have interpreted the Constitution, Parliament cannot change that interpretation. On the other hand, there are 3 types of powers that this court generally exercises. One, you interpret the Constitution. On the other hand, if you interpret a mere statute, again, Parliament cannot override the judgment, but it can change the statute itself.
We have said this is a constitutional convention.
Jeez.
Which category would you bring it? Would you bring in Molasses case and say, okay, we have changed the convention and therefore it goes?
I have humbly disagreed with the very existence of that constitutional convention. I have said that when the Parliament
Geo News Half Hourly Clock is brought to you by
अभी अपने करीबी रिटेलर या माई टेलीनॉर ऐप से ऑफर लगवाओ
and
दे आपको fair and clear skin. Parle 24K Gold Green Beauty Cream.
मंथली इजी कार्ड 800 से पाओ 20 GB डेटा 4000 टेलीनॉर मिनट्स और 350 अदर नेटवर्क मिनट्स सिर्फ 800 रुपए में। अभी अपने करीबी रिटेलर या माई टेलीनॉर ऐप से ऑफर लगवाओ।
Competent to legislate or not? If it is competent, then let us respect the Parliament and not view this as a dictation. It's a law, then competently made. So look at this in that view. But first, let us know whether the Parliament is competent to legislate or not.
So I'll now move on to the competence.
No, I just had a related observation. At the moment we are looking at everything, nothing has happened. What may have happened, what may happen, what the pitfalls are, we are assuming those. I mean, give us this much credit that maybe whether the use dictation is used or any other word is used, may please, if the word please had preceded it, would have made a difference. The question is, this law, one way would be to let it function, and then in its functionality, you may still not be satisfied, or someone may not be satisfied and say, okay, you have not abided by the law. That question, I mean, we are assuming that we are not capable of manning this ship. The only thing is that previously there was the sole pilot, now there are 2 co-pilots, maybe in determining things go wrong, maybe that's a possibility. After all, for instance, when the Chief Justice leaves the country or falls ill, the acting Chief Justice comes in and he assumes the power. So why are we scared of our own shadows? I mean, the co-pilots, if they are there, why we are all assuming that we are leading to the iceberg which lies underneath? Nothing has happened so far. So we are actually, it's all conjecture and surmises we are based on, And the only real question comes down to is the competency. Well, that's the only real question as I see it, which Ijaz had asked the very first day. The focus on that. Either you can make the law, you can't make the law. Now, what may or may not happen, and whether you call it dictation or you call it a request or you call it whatever you want to call it, better way of doing business, being more inclusive, participatory, transparent. I mean, you can give it any adjective or use before that. At the end of the day, it's simply, can they make the law or not? If we even accept that this challenge lies under 184.3, just going ahead and saying, yes, okay, it lies under 184.3, just tell us that this law is constitutional, that's all. Yes. And whether it may not work tomorrow, and then again people will keep challenging it. I mean, people move applications under whatever, Order 26, whatever of the rule, Order 33, where the rule prescribes something to do in a particular manner, they move an application. I could not do so, please condone this. I mean, I don't know how you're going to interpret it when it comes up. So we don't want to tie our hands down how the future will be interpreted. I will come back to Ijaz has been asking, there's only one question, is competency of making this law.
Well, Lord, I move directly to competence. Legislative competence of the Parliament may arise in at least two ways. It may arise through reference to Article 142 and the specific entries in the legislative list, or it may arise through direct authorization by some or other provision of the Constitution. This court has recognized that. I think Mr. Bandhari had also province of Sindh versus MQM. That is 2014 Supreme Court 532 at paragraph 62.
2014 Supreme Court.
532 at paragraph 62.
ये दिखाइए
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों पर फुल कोर्ट समाअत इस वक्त जारी है। मुस्लिम लीग नून के वकील सलाउद्दीन